college, but now I got five children, and life is very busy. But this is a great thing to do. Before this, I was in the mortgage business for a little while, and I saw people take out enormous amounts of debt that they couldn't really afford. And I decided I want to be on the other side of that and helping people make smart decisions with their money. So, John, if you want to take a second, introduce yourself before we get started.
Thank you. I definitely will. And just Jeremy, remember to record everything. So
I did do that. Yes, thank you.
So, all right. So I'm a financial planner. I've been a financial planner since 2005. I see we have a lot of same attendees as from our other seminars, so I'll be short. But was in a family business prior to this. Managed about 100 employees. Saw some transition from family business to a third-party ownership. And because of the things that happened, the lack of planning that I saw really kind of helped me move myself into the financial planning sector to where I wanted to help business owners make better decisions when it comes to exiting their business, strategic planning within their business. So that's kind of what brought me into the financial industry, is just watching small business make decisions. They made a lot of good ones, but they could have made some better ones that would have better set themselves up for the future. So we hope today's webinar will be a good one for you to help you in your planning.
Thanks, John. Hey, Eileen, I'm not able to share my screen at the moment. Can you give me access to do that?
Let me see. How is that? Are you able to now?
Yep, there we go. Okay. All right, hopefully that worked. Okay, so today, this is the third part of simple steps to exiting your business. We are going to, there we go. We're going to talk about estate planning today, and just a disclosure, we are not attorneys, so we don't provide legal or tax advice. We're not tax accountants. We do provide investment advice and insurance advice. So through the process of this webinar, we're going to talk a lot about estate documents that you should work with probably an attorney would be the best choice to help you prepare those kind of documents. This is our contact information. If you need to get a hold of myself or Jonathan Mabb, we'd be happy to speak with you. Well, we do offer a free consultation as well as part of these webinars to give you any advice or guidance in your business or financial planning that you might need. And with that, let's get started. What is estate planning? Well, this common definition is the act of preparing to transfer wealth and assets at death. Estate planning can mean different things to different people. Some people's estate planning is be very basic, and some is going to be very complex. We like a little bit different definition here at MassMutual, our home office. This is the way they define it, and I would agree with this one, and probably most of you would too, is the act of preparing for the maximum transfer of wealth and assets during life and at death in the most tax efficient manner possible. And so we're gonna talk about that not only at death, but during life. There are some estate planning things you do while you're still alive, actually quite a few of them you should be doing while you're alive. But what about protection in the event that you're incapacitated and unable to make decisions for yourself? Do you have necessary healthcare documents in place? Have you designated guardians for your children? That's probably the biggest one I see with people not having a will or any documents in place is, are you going to decide where your children go? Or is the state of Arizona going to decide where your children go if you're not around? And then planning for the costs that are associated with settling your estate, your final expenses, taxes, and other administrative costs that might come along with estate planning. The funny thing is 74% or over 70% of business owners are not actually that concerned about the estate tax part of the equation. As this slide says, 74% don't have anything in place for paying estate tax liabilities. And maybe that's because Congress and over the last several years has increased the amount that you have to have, the valuation that you have to have. And so it's just not top of mind for business owners. But what is top of mind is a fair and equitable distribution at as part of your estate, like making sure that each of your children are getting a fair share, which is a little bit more difficult when you're a business owner. And about half of business owners say they have some kind of estate plan in place, which is better, much better than the general population. If you ask someone on the street or did a poll, not a lot of people have put their estate plan documents in place. But there might be a lot of pieces missing, and we'll talk about that today for business owners and the things that they need to consider. So what is estate planning? Well, it allows you to control what happens in your future when you're not here. And these are the most important points of estate planning. First, who gets what? How are they going to get it? And more importantly, when are they going to get it? I'm sure most of you on the webinar would agree that an 18-year-old probably isn't going to be the person to take over a multi-million-dollar business. And so who gets it and when they get it is extremely important in estate planning. Maximizing the size of the estate that transfers to the next generation, or whoever your intended beneficiaries are, while minimizing your estate taxes and the administrative expenses that are required to settle that estate. And finally, providing liquidity to pay any of those expenses or estate taxes that may occur, which is a big deal. If you think about like a rancher or somebody who has a real estate business where all of their assets are tied up and not very liquid, if you haven't done proper planning and you end up owing taxes, those are due within 9 months. And so if you're going to have to sell a business or sell a ranch or sell something on a forced liquidation, you probably don't get the best price. And so proper planning is very important. And with you, all of you as being business owners, that's a different asset. And so it takes a little bit more proper planning. All right, I've got a poll question here, so let's get a little interaction. Components of estate planning or documents that are used in estate planning. Let me put this up here. Give me 1 sec. Okay, I gotta find it. It disappeared here. Not seeing the poll questions on here, Eileen. Are they loaded?
Jerry, since you're the host, can you pull up the poll question, please?
Sorry, I watched it.
All right, what estate documents have you prepared? A living will, healthcare proxy, durable power of attorney, last will and testament, revocable living trust, buy-sell agreement, or all of the above? So if we can get some answers coming in here. How are we looking over there, Jerry? We got some answers coming in. I can't see the answers since I'm.
Oh, I'm sorry. Do you want me to end the poll? So
Yeah.
you've got, yeah, let's see if does that show it on this and share the results? Here you go.
There we go. All right. So we got all over the board a little bit. We've got some living wills, some healthcare proxies, durable power of attorney. Can you see those results, John?
Yes.
Okay. Want to make sure because it kind of came up on a different screen for me. All right, so all of these documents are important. I'm going to walk you through each one really quickly, give you a brief overview of what they do and how important they are.
Jerry, you can go ahead and close that.
Okay, did that come off?
Yes.
Okay. So let's start with a living will. This is as the name describes, something is useful while you're still alive. But if you become incapable of expressing your wishes or desires for healthcare, this is a written document that says what you would want to have in place if you're unable to make those decisions for yourself, which is really helpful for the next person on the list, the healthcare proxy. So if you're in a vegetative state or a coma or you're brain dead or something bad, really bad happens, what should they do in that scenario? A living will spells out your wishes, what you would like to have done in that scenario. And the healthcare proxy, that's a person that you name, also known as maybe a medical power of attorney or a durable power of attorney for healthcare purposes. That's a person that you would designate to make those decisions if you're not able to. If you have a living will, it makes it a lot easier for that person to say, yeah, here's what we're going to do. If you don't have a living will, well, then they have to make the best choice, for whatever they think you would want. So that's what those two documents, they're surrounding healthcare while you're still alive. And then a durable power of attorney is also a document, an estate document that is useful only while you're alive. And a durable power of attorney is for making financial or legal decisions on your behalf. It's kind of interesting. The first time that my wife and I sat down with an attorney to talk about estate planning documents, we had been married for less than 2 years, maybe a year and a half, something. We were expecting our first child. And the attorney looked at us and said, okay, I've got this durable power of attorney I've drafted for you. Are you sure you want this as part of your documents? Because this gives the other person total legal authority to do anything in your name. Open up credit cards, take money out of your bank accounts, buy a car in your name, buy a house in your name. I mean, literally anything this person could do for you. And we're like, yeah, of course. And then she kind of like looked at us like, are you really sure you want to have this kind of power over each other? You're barely married. Like she was sort of looking at us as these two little kids, we're in our early 20s. We're like, yeah, of course. What could ever go wrong? And so obviously she was coming from a perspective that she'd seen divorces, she'd seen ugly things happen. And a durable power of attorney is quite a powerful document. So not all of those are created equal. You can create them that say, this is only effective if I'm incapacitated, or this is only effective if a doctor says I'm not able to make sound financial decisions. And so those durable power of attorney can be drafted in different ways. A will or a last will and testament, that's a document that designates who gets your assets at the end of life, who takes care of your children, who would you have to be the guardian of your children. And that's a document that everybody should have. If you don't have one, guess what? The state of Arizona has created one for you, and they have a list of here's who we would choose for guardianship. Here's what we would choose for who gets your assets next. And it may not be what you were hoping for. And then a revocable living trust. This is a document that creates almost like a new person. Like the way I think about this is, if I create a living trust, I just created my little avatar, my online personality sort of a thing that never dies. So it's something that is alive, but I control it. So I'm a trustee. I create this revocable living trust. It's this person that never dies, this document, this entity that never dies. And the way that the living trust is going to be effective is I am going to give all of my assets to this trust. So my trust is now owning my bank accounts, my cars, my house. It owns everything. So if Jeremy Cook dies, nothing changes. My trust owns everything. The only thing that changes is who gets to control that trust. And so it would be my spouse, or it would be whoever I named as the second trustee. And they have to do what I say in that trust. So I can control some of my assets. For example, I could say, well, I don't want my children to get anything until they graduate high school. Well, except for maybe their care and maintenance while they're young. But I don't want them to get any lump sum of money until they graduate high school, or they graduate college, they get another chunk, or they get married, they get a chunk of money, and then they don't get anything else till they're 35, or a down payment on a house, they can get access to the money for that. And so it gives you a lot more control when you're not around to see where the assets go, who they go to, when they go there. And then for business owners, this last one, it's a buy-sell agreement. And this one is, if I die or if I become disabled, what happens to my business assets in that event? And for John and I, right, we're business partners. He would buy my business from me and pay my estate, pay my spouse or my children or whoever my trust, actually, who he'd end up paying. And so now he owns the business and he takes it over and he pays out my estate and my trust, the fair value of that business based on the buy-sell agreement that is triggered. So those are the documents that people should be considering as part of an estate plan. And for business owners, you probably should have all of these in place. So what do business owners actually have in place? Okay, let's see if we can get this to click forward. Okay. Well, wills and trusts are top of the list. About 50% of business owners say they've created some kind of living revocable trust or a will. But some of these other ones, things that should be considered for business owners, haven't done so well. 33% have done a formal valuation, which is critical for the buy-sell agreements or planning for your estate in the future. And we're going to go through a case study later on about business valuations. Estate equalization strategies and reduction strategies. So these are some things we'll talk about today. Before we get there, though, let's talk about probate real quick. Probate's the legal process of distributing your assets after your death, either in accordance to your will, if you have one, or if you don't have one, according to the state intestacy laws. So the great state of Arizona has created a will on your behalf. So what goes through probate? Well, your car, your house, your cash, your business. If you don't have documents in place, all those things are going to pass through the probate courts. And probate, it's got pros and cons. Okay, it's expensive, time consuming. The assets are tied up, so your children may not get access to your bank accounts or your business or things during probate, or if they need to, they have to go petition the court to be able to do that. And then once it passes through probate, which is the process of proving your will if you have one, then it finally gets to the beneficiaries and the heirs. There is a advantage or probably just one or two advantages of probate. One is it does limit the amount of time in which someone can challenge your estate, or creditors can try to come after your estate. But mostly there's disadvantages because, like I mentioned, that the survivors may not have access to some of your assets, the fees for the court, the fees for the attorneys, your executor, appraisals, accounting fees, those kind of things are more expensive through probate. And probate's public, so it's a matter of public record what happens to your estate. So how can you avoid probate? Because you can avoid going through probate. Well, a couple of things. The bottom one here, assets owned in a revocable trust. So if I remember, I created my avatar, I created my living trust. Well, when I die, I don't own anything. So there's no need to go through a probate process because I'm not the owner of any of my assets. My revocable living trust owns them. And so there's no probate process. Assets with beneficiary designations. So if you've created 401k plans or IRAs, or you have a life insurance policy, any of those types of products are structured with through contract law, and so they have beneficiaries that you name, and then those will pass directly to those beneficiaries outside of probate. And then finally, joint tenancies. You can title your assets in a way to where they would pass automatically to somebody without having to go through probate. And the most common of that is joint tenant with right of survivorship. So if any of you bought a home, the title company typically asks you, do you want to title this in your name, in the name, you and your spouse with right of survivorship? So you can title assets to where they would pass automatically and not go through the probate process. And that's critically important. I actually had a client a couple of years ago. They had titled an investment account in both of their names. It was a joint account. So when they saw the statements, they had both names on it. But it was actually titled as joint tenants in common. And in the state of Arizona, it's a community property state. They consider everything owned jointly between husband and wife, unless it's a second marriage. And in that case, when the first spouse passed away, because it was not a right of survivorship, the state laws, and they didn't have a will, so the laws of the state came into play and said, actually, because it's a second marriage, the half belonging to the spouse that passed away actually goes to her children. And it was quite the learning process, and took a lot of paperwork and attorney work to prove that her original intent was right of survivorship. And so you just want to make sure you title things properly. And finally, estate taxation. Not top of mind for a lot of people, and this is probably the reason why there's some exemptions. You've got first your marital exemption. So if you're going to pass money to your spouse, they have unlimited. You can pass everything that you own to a spouse with no tax due. Except for one exception of that, if your spouse is not a U.S. citizen and the survivor is the non-U.S. citizen, they don't get an unlimited marital deduction. The estate tax exemption per person is $12 million. So if you're married, that's $24 million. So most people, this isn't top of mind because these limits have gone up so much. However, in 2026, when this current tax law changes, this is going to revert back to $6 million per person, which is still a really large chunk. And then the other thing to consider is you can gift $16,000 of value per year to any person that you want. Most people would obviously give that to children or grandchildren, but just consider if you had a child and they were married, you give $16,000 to the child, $16,000 to the spouse. You don't have to file a gift tax return. It's exempt from any taxation in the future. So if you did that for multiple children or multiple grandchildren, and you were trying to reduce how much was going to be included in your estate, you could really gift away a lot of assets before you pass away. Now, if you gift more than $16,000 a year, you do have to file a gift tax return, and that's going to come off of the $12 million later on. All right, so what are some steps you could take? Talked about kind of the process, talked about some of the documents. What are some of the things that business owners are missing? Because a lot of them have a trust or a will in place, but what are some of the steps you could take? So we've got estate reduction, gifting some of the business while you're alive, estate liquidity, avoiding a forced liquidation of your business, equalizing your estate. So when some family members are working in the business and some aren't, how do you make that fair and equal? And finally, business valuation. How and by whom does the business get valued? And there's an interesting case study we'll look at. So first up, estate reduction. Now, it sounds kind of interesting because you're thinking, I want to maximize the amount of value that's passed on to my heirs, and yet the first step is to reduce the value of your estate. Well, we're talking about reducing the value of your estate so that you pay less estate taxes down the road if you're going to be subject to that. And so we've already talked about the first one, lifetime gifts. So remember, you can give $16,000 to a person per year, and that doesn't pass, bypasses any estate taxation, or it doesn't use up that $12 million exemption. And so that's a great way that you can reduce the value of your estate and pass it to the next generation. And then this other one, the family limited partnership. This one's a great one, especially for a closely held business where you are trying to pass it to the children. It essentially transfers the senior family members or the owners of the business, transfer the value to their children and remove it. The value of the business is removed from their estate. The value of their estate for federal estate tax purposes, but they still get to maintain control over the asset and decision-making power. And this allows for something called valuation discounts, and we'll get a little bit more into that in a minute. But because the new owners, the children being the new owners of the business, don't have control, then they can get some discounts on valuation of the family limited partnership. So this can be a great way to pass a closely held family business. Second step we'll talk about is estate liquidity. So this is, like those ranchers or the real estate businesses or businesses that have a lot of assets but not a lot of cash. This is a way to gain access to cash because those taxes are due within 9 months. So what would you need liquidity for? Well, to pay for probate, to pay for legal and accounting fees, to buy out business owner or family members that are not in the business. If you think about a business that, they have 3 children, but only 1 child's in the business and they want to own it. Well, now they got to buy out these other children and they need cash to be able to do that. Paying off debts. And obviously the last one is paying estate taxes, which can be anywhere from 18 to 40% of the value of the business. So what are some ways to get liquidity from a business? Well, there's only a couple, right? There's you can sell some of the assets. You can borrow, which could be difficult, or you can have a life insurance policy that comes into play. And most of the time, typically, if you're going to choose one of these options, liquidating the business is rarely the best choice, because the business is now going to be gone. It's going to be discounted because it's typically a forced liquidation. And so you rarely get the true value. And the heirs just simply lose out on the difference between what the business was really worth and what they actually got for it, because it had to be sold so quickly. This actually happened to my uncle. He passed away unexpectedly. He had a dental business, and they were forced to sell it because they didn't have any dentist to work in there, and they didn't have a buy-sell agreement in place with anybody, and they got a lot less for it than what it really was worth. Borrowing. So instead of selling, you could try to borrow to raise cash. Kind of difficult. Sometimes I would say most times lenders maybe are not going to be willing to make a big loan like that when business owners die, or at a reasonable rate. The executor has to keep the entire estate open during the servicing of that loan. And so that's extra delays or extra costs to the estate. And then finally, we've got life insurance. So life insurance is something that would come in immediately upon a death as a influx of cash. Life insurance death benefits are not subject to income taxes. However, it would be part of the estate unless you did some proper planning up ahead. And maybe, I'm not sure if anyone's heard of irrevocable life insurance trust, sometimes called an ILIT, I-L-I-T. But that's a way that you can buy a life insurance policy, fund it every year, and then the value of that life insurance policy, the death benefit value, when it's paid out, is paid outside of the estate. And so it doesn't add to your estate for federal estate tax purposes. So each of these has a cost, right? The direct cost at the bottom there, a discount. If you liquidate the asset, you may get a discount price. If you borrow, you've got to pay the debt service and the interest. And life insurance, you've got to pay premiums every single year. But this is a way to meet liquidity in the event of a unexpected death. All right. This was estate equalization. This is kind of a big one because a lot of people have more than one child, but not all of their children are working in the business. So I actually got a poll question here too. Jerry, there's poll question number 2. If you could bring that up. I'm kind of curious what people think about passing on their business. Or Eileen, I'm not sure.
I'm doing it.
Right,
Poll
okay.
number 2 here. Can you see it?
Yeah.
Not
Oh, not that question. I guess it's
Sorry.
maybe it's the other question. How you divide up business ownership is the question.
There.
There we go. So how will you divide up your business ownership? Equally among your children, regardless of their involvement in the business? Children working in the business get it, and the other ones get other assets? Children can make that decision themselves, or it doesn't really matter to you? Let's get some responses here on this poll question and see if we match the business study that Mass Mutual did a few years ago.
So I'm going to end the poll. It looks like everybody's answering the same question.
Wow, look at that. Equally among the children, regardless of business involvement. 100%. Wow. It's pretty good. So if that's going to be if that's going to be the way that most everyone on here is going to want to do it, how do you make that equitable, or how do you make that fair when some are working in the business and some aren't? And John's actually going to bring up an interesting case about this in a minute. Let me see if I can get back control here. Okay, so when it comes to business, fair doesn't always mean equal. So estate equalization, you might have to make some hard decisions, giving the business to children working in it versus those not involved, receiving business interests versus giving them other types of assets, receiving liquid assets versus illiquid assets. So if you're considering, a business that has a bunch of value to it, right? It's worth a lot of money, but it's not the same as cash, And so if you're going to give some kids a bunch of cash and others the business, is that a fair value, a fair difference? And then giving business or receiving an inheritance today versus in the future. The one thing I would say about this is communication is key. Talking to your children about it, especially if there's some in the business and some outside of the business, and communicating what your intentions are and what your plans are, could eliminate a lot of contention that might happen down the road between someone working in the business and someone not working in the business. So John, I think that's where you might want to talk about a little bit about a interesting
case study. So real quick thought, these things are extremely important to me. I'll look just real quick about my family business that I grew up in and kind of how, because I watched transfer happen. So my grandfather owned a business. He shared it with his wife. It was a second marriage. And so when his wife passed away, one of her sons inherited a third of the business and shared that because she was concerned about possibly that son getting written out of the will if she passed away. So very, very interesting and design. And then later my grandfather passed away and two of the other children received assets, including my father. And then there was his sister received a completely different asset outside the business. And so transition is always a very interesting thing. And, there's a lot of feelings that we saw that people felt was unfair, but one of the important things, like Jeremy mentioned, was communication. So my father actually told us, because he had 5 sons, and he goes, look, I only own 1/3 of this business. There's no way I can split 1/3 into fifths. So he told us very early in his that his plan was to sell the business eventually. He did not see how he could transfer that. So I always appreciated that communication. So we got another business that we kind of want to share with you a little bit. I'm going to have you bear with me, but I want you guys, we're going to have you answer in the chat. So be ready to answer this in the chat. There's 2 questions that we want you to answer. One is, do you think it's fair what this business decided to do with their family? So there's the fair question. And then what other options could the parents have considered? So if you think about it, what other options or things could they have done? So those are the 2 questions that you're going to answer. Feel free to put your input in the chat at any moment in time. So what we have is we have a husband and wife. They owned a school uniform manufacturing business. They had 4 adult children. And over the years, 3 of the 4 children left the business. They kind of just saw the writing on the wall. They just didn't want to work with mom and dad. Who knows what the reasons? They just decided to create and start their own career paths. So one of their children, their daughter, decided to stay in the business. And so she stayed in the business. She continued to work in the business. And over time, the parents decided that, hey, it's time to do some transfer. And so their parents decided to do an ownership transfer. And what they decided to do is they were going to give 50% of the business to their 4 children right now. And they were going to keep 50% of the business for themselves. So they wanted to do that estate transfer 50-50. the 4 kids would split up that 50%. They decided to add a little extra feature in this, and they says, well, if you decide to work in the business, what happens is your siblings that are not working in the business have to give up 1% of their current ownership for every year they don't work in the business. So this one daughter over time is going to receive greater ownership of that 50% because she's working in the business, but the other kids are going to have their piece start to dwindle for the longer they stay out of the business. The last piece of this is that the parents decided that when they passed away, that other 50% would be divided again amongst the 4 children. So do you guys think it's fair? Who thinks it's fair? Who thinks it's unfair as far as this plan? Go ahead and type it in chat for us if you could. Okay, so we got a couple votes for fair. So in this situation, the daughter actually that was working in the business, she felt it was unfair. And that's what she expressed her concern to her parents. She says, I don't think it's fair because I'm working in the business and my siblings have second careers. So my siblings, after you pass away, are going to have 2 incomes, one from the business that I'm working in and one from the career they're currently working in. I don't see a value of me staying in the business because I'm only going to receive that 1 income, and therefore it's not fair. So there was a little bit different. So what are some other options? You know, how else could parents transfer ownership in this case? Is there any other thoughts that they could do instead of just giving 50% of the actual business to the kids? Is there anything else that they could on their death? Any thoughts in chat? What do you think, Jeremy? Is there anything else that they could add?
I think they could add a liquidity structure.
So, all right, we got a few things.
Buyout options, right?
So
That's
buyout options, just
buyout
could
options.
buy them out. You know, I think that's absolutely one of the components that they could honestly put in this is some buyout options. They could consider funding it with life insurance. And so if this daughter really wanted to assume complete ownership, the parents could then say, well, let's figure out a way to buy your siblings out. And whether it's a life insurance funded by the business or whether the daughter has to decide to put her money in to buy that life insurance, there's several different strategies that she could do to obtain complete ownership. Personally, I think the parents really did try to do a very good way. I mean, it's a very strategic method of them trying to transfer that ownership, trying to reward the daughter for staying in the business. The key thing we hope that you guys get out of this is that the creativity is a good thing and having conversation is a good thing. And so every business is a little bit different and your plan doesn't need to match someone else's. And so that's why it's very helpful for you to meet with other individuals, to run different strategies off with them, whether that's your attorney, whether that's a financial planner, whether that is a business consultant that helps with transferring ownership. Having those conversations with those individuals can really help you design a plan that best fits your family and your business. So there you go, Jeremy.
Yeah, for sure. Thanks for sharing that. It's a tricky one, but I think the buyout or the liquidity event, you know, having some other asset, cash or other assets or something that came in to help pay off the others would make the other daughter, the working daughter, feel a little bit better.
I mean, it's very similar to like a buy-sell agreement. We talked a little bit about buy-sells, and you know, one of the questions I talk to when I'm working with business partners is, do you want the spouse to be your partner's business partner? or better yet, would your spouse want to be the business partner of that? And so that's not always the case. And so finding a way to help create that liquidity to buy out that individual is usually a very helpful thing.
That's for sure. All right, let's move along here. We don't have a lot more time, but a couple of items to get through. One is valuation. John talked about this in our very first session 2 weeks ago. But critical component is understanding how will your business be valued and who's going to value it. The IRS, they would love to value it for you. If you don't have some way to value that business or some formula, some standard way to do it, and include that valuation in your estate planning documents. Buy-sell agreement should always have some kind of formula for valuation or how you determine the value of that business. The IRS defines fair market value as the price at which property would change hands between a willing buyer and a willing seller, neither being under any compulsion to buy or sell, and both having reasonable knowledge of the facts. So we're going to do another case study in a second that shows you how two different persons evaluating the business, the owner versus the IRS, and how different it could be. Will the IRS accept a valuation done for buy-sell purposes? Well, they will. If it's between non-family members, it's got to have these 4 components in it. The agreement's got to be is bona fide and not a device to transfer the business for less than adequate consideration. The agreement establishes a reasonable and ascertainable price. The price set in agreement applies to both lifetime sales and sales at death. And a deceased owner's estate is obligated to sell the business at his or her death. And so a buy-sell agreement valuation, whatever value you came up for that, it could be used to satisfy the IRS. If it's between family members, it's got to meet all those 4 requirements, but it also has to meet a comparability requirement, which is, it's kind of like their way of making sure this was more of an arm's length transaction. So it has to be a similar or a fair bargain if these were unrelated parties. If I was not a family member and another unrelated party and we were going to come to an agreement, it had to be something similar to that if it was 2 family members. It has to follow general business practices of unrelated parties and be similar in result to negotiated agreements of unrelated parties. And so it can work if it's a family owned buy-sell agreement for valuation purposes when the IRS looks at it. It's just got to meet all of these different requirements. It can't be like, yeah, I'm selling my business to my son for $100,000 when the business was really worth $1 million out on the market. So, but there are some discounts you can get for family businesses. So we talked earlier a little bit about family limited partnerships. Well, if you're going to create a family limited partnership where the parents or the senior members of that business still maintain control, and the younger owners have a lot of things they have to abide by from the older owners, well, that makes it lack of control, lack of marketability. Someone else isn't going to want to buy that from them, and they have minority interest at the time. So those types of things can lead to shrinking the value of the business for estate planning purposes, which means it could be a smaller value for estate taxation, where the IRS looks at it and they say, well, there's these other, blockage, which means the stock is more valuable because it can block certain other transactions and control, which means that if holding a stock of a certain size, it effectively controls all of the business decisions, the strategic decisions of the business. So the IRS, basically the IRS wants to increase that value for taxation purposes, the owners want to decrease that value for taxation purposes, and it can sometimes get a little messy. So the bottom line is, if you get an appraisal done, like a credentialed appraisal, it can eliminate a lot of these problems. Oh yeah, this is a good one. So John's going to go through this other case study, and then we'll pretty much wrap it up. And there's a poll question that comes with this one in a minute on the next slide. So,
all right. So real quick, I know we're talking a little bit about estate taxes, but if there's acquisition, when people are buying shares of someone, there's also taxation there. So having a good plan can help with that taxation of buying someone out, and the shares, whether it's a business partner or whether it's siblings. So it's really important that you meet with someone and set up the proper taxation plan. So here's a quick case study on this. What we have is the state of Thompson versus commissioner. Miss Thompson died in 1998. She owned 25% of the stock in Thomas Publishing Company. Thomas is a leading publisher of business-to-business catalogs, newsletters, etc. They're very successful, profitable company that in 1998 had revenues over 250 million. However, the internet was coming around, and so there was a lot of concerns about the internet and how that would impact it. With that concern about the internet, they were starting to apply or planning to use a lot of cash to help expand their company in a different method. And they actually saw subscriptions going down on the printable and subscriptions going up on their internet. So Jeremy, go ahead, go to the next slide. So they came down and they needed to do a final valuation. So final valuation of the company was done on May 2nd, 1998. And on this day, the business balance sheet showed total net sales of 257 million, total net income of 28 million, and total liquid investments of 98 million. They were also planning on using that 98 million for business expansion into the internet base. So question is what do you think the value is? So Jerry, can you put up that poll question real quick? And
Sure.
all right, so what do you think that the business value is? 25 million, 110 million, or 225 million? I can tell you the IRS wants 225 in this, and that's what they were going for. The business was wanting 25 million because they wanted to pay the least amount of taxes. So not sure we got, go ahead and close that out. All right, the poll said it wouldn't let you vote. A couple of them. Did we get?
Let me.
It's
see.
all right. For time's sake, I think we'll just let it be. Because we're running up on the end of the time and I want to be conscious of that. Really what it came down to is it went to tax court. In tax court, they settled on $110 million is what it valued at. So there's several different things when it comes to valuation. You know, there's definitely the valuation put more bang in your pocket, but in this situation, the valuation was more along the lines of wanting to protect the taxable cost of it. So there's different purposes of it, and having this structure set up in the beginning of knowing what to do is extremely important. So Jeremy?
Yeah, and if you can imagine, I mean, if the IRS got their 225 million valuation and they had to pay 40% of that to estate taxes, well, there goes all the cash from the business just to pay estate taxes. And how could they expand into the internet or do something else that they were trying to do? So one thing that they could use to help fund that would be life insurance. And so life insurance is one of the best estate planning tools to provide immediate cash and liquidity. Provides income replacement if you should die prematurely. That's probably what the majority of people use life insurance for, is if I'm not here, how do I provide income for my family? Provides liquidity to pay the estate taxes because those are due within 9 months. It can equalize the estate. So in that scenario earlier where the siblings were going to own part of the company, but only one daughter was working there, this could fund buying them all out. And it could also help fund retirement. All right, so we talked about a few different ways to help you plan for your estate, all the documents that you would need. We want you to be able to transfer your wealth in the most tax efficient manner possible, with the highest going to the heirs and the lowest amount going to the IRS. And with that, we will turn it back over to Jerry to end. Thank you for your
Thank
time.
you. Thank you. That was really interesting. I have one question before I move on to my slides. When you were talking about the estate planning and the revocable wills, and what would you recommend if someone has no family members and no children, and they set up a will and all of their friends are older than them? So who do they recommend as a trustee? Because there's no family members and all of their friends are their age or older. So who do you recommend be the trustee in that scenario?
That's a great question. And there are professional trustees.
Mhm.
So you can hire a trust company like a bank, or actually Mass Mutual has a trust company. You can actually hire them to manage all of the assets and pay them out to whoever is named in your trust. So if it's like charitable organizations or other places that you wanted money to go to, you can actually hire these trustees, and they can manage all the assets and manage all the distributions per whatever wishes that you have.
Mhm. Okay, cool. Is there a list where people can find, or you just Google it for your area, or and one trustee
Google it
isn't
for
the
your
same as
area.
another, right?
You could ask us, we could give you some recommendations. But yeah, depending on where you live, you might want to just find someone that you're comfortable with and look at the fees and compare, one trust company versus another. But it's mostly banks or big insurance companies that would offer this kind of service.
Okay, cool. Just thought that would be an interesting response, something interesting to consider. So let me just take the screen here and share my PowerPoint again. Get the photos out of the way. My Wi-Fi is really slow, so I apologize for how long this is taking. But what I wanted to do was just cover some information about the counseling services and how you can access SBDC services. So the first step is to register at this website, https://maricopa-sbdc.com. And when you do that, you'll get into our confidential system, confidential database, and then you'll be assigned an advisor, and Eileen's the one that does that right now. So you get assigned one of our 15 counselors. Everyone has a wide variety of expertise. So depending on what you've put in the application, you'll get assigned to one of the counselors that has the industry experience and or expertise you're looking for. Then that person will reach out to you to schedule an initial counseling session, go through some background about the SBDC and how we work together. There'll be some follow-on sessions that are scheduled between the client and the counselor for as long as you need to work with us and get some assistance. The counselor might even bring in another co-counselor, either from our center or from someone else within the network, to help you with your business process and planning and growth. We work with clients who are in the startup phase, who are growing their business, who are actually, we even get into the exit strategy process. We have some counselors who are skilled at exporting, and some that are really skilled at angel investors and bringing angel investors in. So we'll help you grow the business, track your goals, and work towards achieving whatever those business goals are. And right now we're working exclusively remotely. We are only in the office one day a week, but most of us work remotely. So we counsel via Zoom, and counseling is by appointment only. We have a relationship with Arizona Commerce Authority. So we have access to additional tools that are through the Arizona Commerce Authority. We also have relationships with the County of Maricopa and the City of Peoria and some other cities. So a wide variety of resources. Just wanted to say thank you for joining us, and thank you to Jonathan and Jeremy. This was really a very interesting session for me and a whole series. So really appreciate your time in joining us today.
Thank you.
Thank you. You're welcome.
And if we don't have any other, questions, that looks like there might be a comment in the chat. Eileen will send you the webinar slides. I see that people are asking for those, and all of these recordings are also on our website, so you can access them again at no charge and review all three at your leisure. So thank you once again, and have a great rest of your day.